for joining us this afternoon for the Fall 2024 Fair Trial Free Press Conference. My name is Chell Miller. I'm the Program Director at the Government Law Center here at Albany Law School. And on behalf of the GLC, thank you all for spending your afternoon with us today. As a matter of housekeeping, we have our program, which will go until 4 o'clock. It's 2 o'clock now. About 3:45, we'll have an opportunity for audience Q&A and some discussion. For now, just kind of sit back, relax, and listen to this really exciting, lively panel. As some background, the New York Fair Trial Free Press Conference was established in 1969 by then Chief Judge Stanley Fold to bring together members of the press and the criminal legal system to promote understanding and to assure the right to a fair trial and protection of the free press. At every program, a distinguished panel of judges, lawyers, journalists, and sometimes law enforcement officials explore the legal, political, and ethical issues that arise in a hypothetical scenario, including the responsibility and liability of the courts, law enforcement agencies, and the press. You should have a copy of the hypothetical scenario in your hands if you haven't already. You also received it by email if you registered ahead of time. The Government Law Center at Albany Law School and the New York Fair Trial Free Press Conference, which is a nonprofit corporation, have collaboratively presented the Fair Trial Free Press Conference on a biannual basis since 2022. We are honored to bring this historic program here to the law school and to continue its legacy. With that, I am going to pass the mic, so to speak, to one of our co-moderators, Rex Smith, a former editor at the Times-Union. Many of you might have heard him elsewhere. Thank you.
Thank you, Jill. Really appreciate your time. I will be joined here shortly by my co-moderator, retired Court of Appeals Judge Al Rosenblatt, who is not yet with us thanks to the exigencies of travel from Poughkeepsie on Amtrak. But he will be here shortly and will pick up a microphone and jump in with moderation. Let me just introduce you to the panel who will be asked to play some roles in this scenario, roles roughly similar to those that they might play in real life or that they might have played. First up on the screen, the most prominent person, Ojasvinee. Sorry, you're up there. You can't see this, OJ, but you are right there in front of all of us. As you can see, I'm looking up here. Thank you for being here.
Thank you for having me.
Yeah, and you'll jump in whenever you need to, and I'll call on you sometimes. OJ is playing a role. She's a media lawyer with Penguin Random House and is therefore, and here's Judge Rosenblatt. What great timing is that? So she is will play the role of newsroom counsel for us here for the journalists. Let me introduce Judge Garry, Honorable Elizabeth Garry, who is the presiding justice of the Third Department. Thank you for being here today. We appreciate that. And over on this side of the room, the District Attorney of Ulster County, Emmanuel Nneji. We appreciate your presence as well. Right next to him is the guy who will be playing the role of a defense lawyer and maybe will ask you to be a plaintiff's lawyer at some point, depending on how the circumstance goes here. William Easton, Rochester, supposedly retired partner, and Easton, Thompson, Kasperek, Shiffrin. Next, where'd you go? Here we go. Garry Craig, from a longtime investigative and watchdog reporter for the Democrat and Chronicle in Rochester, and is here to pretend to be a reporter. It actually does it in real life. Over on this side, another journalist, Erica Smith, managing editor for Digital of the Times-Union. So we will ask her to intersect with us with this scenario in the way that a journalist thinking primarily about digital presentation would think. Most consumers get their news now digitally, of course. So it is not unusual for us to think this way, and many of us who began our careers in print, I started so long ago that every reporter had a glue pot on their desk, a paste pot. You might not even know what that is, but cut and paste was literally cut and paste with paper. So those of us have had, who started in that way have had to think about digital and how differently that affects the way we approach what we're doing and the way we think about publishing. And then Professor Garry Craig, Professor Steve Clark, who is, well, you could be a professor. Professor Steve Clark here of Albany Law School, who will play the role of sort of all-around expert on these issues as we explore them, believing that we have here something that is virtually snatched from the headlines, because some of these issues in this scenario are really those that are either what we are confronting day to day in the exercise of the journalistic enterprise and the exercise of the effort to find justice for those accused in our system, or they're those that we're about to find, those that we're about to encounter. And Judge Rosenblatt and I, who have done this sort of co-moderating task, a little tag team thing for many years, will sort of alternate on who asks the questions and who steps out of the camera for just a moment every now and then. So if you haven't read the hypothetical, we'll help you out with it a little bit. We start with an understanding of what's going on in the legislative chamber. You may think of the, for example, the lobby outside the assembly chamber just down the street, or the lobby of the Senate, where State Senator Terry Lennox, a brash lawmaker, let's for fun make him a likely candidate for governor with a significant following in the state, who's known for slashing rhetorical attacks. You may know that there are some politicians who do such things. Had a fiery performance on the Senate floor, and he was confronted by a lawmaker from the other side of the aisle who objected to his suggestion of corruption. And there are 4 witnesses in the Capitol corridor to the shouting match that ensued, shoving contest, and the inflammatory Senator Lennox throws a roundhouse punch that sends the other lawmaker onto a piece of stonework, let's say there on the edge of the $1 million staircase, knocks him unconscious and leaves him with a lacerated scalp. Let me just intersect before we go any further and ask the reporter who's present, who might not have witnessed this, but might have heard that there's a hubbub, and perhaps you run to talk to people who are there. Do you have any hesitation, anything that the reporter might stumble upon here? Do you report quickly what you've heard from eyewitnesses?
Yeah. Well, you're touching on one of the sort of the difficulties of the day with the haste of social media, that you still want to be right first. But if you have witnesses there that witnessed it, yeah, I would probably not hesitate to, go to Twitter, Blue Sky, whatever people are on these days. And once I felt certain that they truly had witnessed this, and would start sort of putting out what they had to say about it, then sort of constructing the story from there.
Do you have any concern about your witnesses perhaps being partisans, since we've heard that some partisans don't necessarily speak facts?
That's unusual. That is something, I mean, you're definitely having to filter that out. That's why I think with a scenario, if we have 4, I'm sort of looking for the likenesses with a story, as with any other sort of eyewitness / account. You're trying to sort of build a fact-based account, and you find those similarities in what's been told to you, and hopefully you can sort of filter out any of that bias.
Right. And Erica Smith, you're the editor for reporter Craig here. You're trying to decide whether you're going to publish this. You understood that he's been taken into custody by 2 Capitol police officers. That is, the senator has been taken into custody. Do you have any concern about publishing something that you've heard reported that he's now been arrested? And maybe you've even heard that he actually said to the police officers, "I'm glad I had a chance to clock that SOB. I've been wanting to do that for a long time." So you hear this, you ready to go with that?
I'm already writing that headline, in my head at least. I mean, there's always, to say there's no concern would be wrong. There's always some concern. But if I trust my reporter, trust his reporting, then yeah, we're gonna go with it.
And do you give equal weight to competing versions of events? For example, Lennox pleads not guilty. Let's say that for some reason he decides to enter a plea at arraignment. maybe there's an opportunity for that in some states, and claims that what witnesses describe as a punch was merely his effort to push his opponent away from him who was actually assaulting him. How do you decide what to do when you have competing versions of facts?
I think we represent both sides, but that doesn't mean that they are represented in the same way necessarily. If we have one person who says, no, 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 I merely brushed past him, he tripped over his own feet, hit his head, it's his own fault. That is one account, but if we have 5 other people with a different viewpoint, then that also weighs in. So you've got 1 against 5, you present that all to the readers, the people.
And just curious, since we're talking about fair trial here, in any of these considerations at this stage in covering something that's going on, do you worry at all about what is down the road potentially tainting a jury? Does that ever enter your mind at this point?
I'm point blank, it's not my job.
Good. That's what I thought you would say. There we go. And I think, do we all agree? Let me just ask your counsel here, OJ Singh, do you agree that your reporter and editor shouldn't really be worried about the consequence of their reporting on what may ultimately be a criminal case?
Well, they have the opportunity to comment and opine on the facts that are disclosed if the general chatter at that moment in time says that the senator assaulted someone and there are competing versions of that sequence of events. They have the right to keep on reporting on the situation that is evolving, and oftentimes reporters do include that disclaimer at the bottom of their article saying, the situation is evolving, we will continue to update the article as soon as we access the information. So they do have the right to opine on the disclosed facts and keep on, evolving their reporting on the facts in a neutral way.
Hey, thank you. That's actually really good transcription service, isn't it? That's better than most. The quick transcription in print of what we're seeing. So congratulations, folks. I don't know if that's powered by AI. Al, we're about to get to the point here of the Daily Tattle, an upstart tabloid that is really excited about this incident, and they decided to do something remarkable, which is let's use this generative AI to augment the journalism and have a digital engineer develop an AI-generated reenactment of the confrontation based on the account of the 4 witnesses. And they produce, a remarkably effective clip. Where do we go from here?
Well, that's intrigued me too, because.
Let's get that microphone on here, I think we. Yeah, that's pushed.
Pushed. Oh, okay, it's pushed. So it intrigued me also because we're going to be living in an AI world, or many of you, the younger you are, the more you're going to see of AI. To us, it's largely a mystery to someone of my age, except insofar as I teach at a law school, and we had an assignment in which students wrote briefs. And just to see what would happen, we punched in the facts and asked for a brief based on AI, the same assignment that the students get, that they wrote briefs. And I was somewhat dismayed to see that it came out as pure gibberish. It made no sense. So I'm going to ask the media people, the Tattler, is the editor of the Tattle on hand? That given that one's experience with AI has been to produce something which is inaccurate at least, and at worst, monstrously distorted. Is that anything that you would want to pin on someone and ascribe to them in behavior that could wreck their political career?
So I think it depends what we're using for AI as a starting point. I can tell you that we have some AI tools that we use in the newsroom, the real newsroom, not this fictitious one, but it's much tamer than what we're talking about now, right? All of that has been trained off of information we edit, we own, we manage. So it depends on what kind of system we're looking at. If we just turned to ChatGPT and said, hey, create this thing and we're going to publish it, I myself have some qualms with that. I think that no matter what, we have to be upfront with people to say, this was produced by AI. This is how we did that.
So you say you plaster that all over. Let's say you did it and it looked plausible, but it had a distinct orientation and a viewpoint. So now in the inevitable lawsuit to follow for defamation, what would the lawyers say faced with a complaint that said that the tattle ran this AI just hoping that the engineering would work out, and yet it showed the battery to be far worse than even the witnesses, and no amount of disclaimer is going to save one's reputation? How do you answer a complaint like that?
Depends if you're asking me or my lawyer. OJ?
Yeah, you better ask,
Let me ask the lawyers.
I'm gonna ask you,
Lawyers saying,
the media
yeah.
counsel up there. OJ?
Yeah.
Yes. Again, I think reporters are allowed and have for decades published reenactments of events on the ground. We've oftentimes seen broadcast news, do those digital animation reenactments of shootings and the like. And this is not a new practice. The tool is different. The tool is new. It's novel, and it relies upon a very different type of technology that doesn't really involve human editors. However, reporters have the right to report on things that are of the public interest. They have the right to be able to use their tools to report on things that are newsworthy, and a senator assaulting someone and then claiming whatever he claims about the assault is newsworthy because it's a sitting lawmaker. It is of the public interest because the public has the right to know what their lawmakers are up to, what their character is, how they behave outside of a legislature. And it's just their opinion that the event was exaggerated by the AI-generated tool. The disclaimer in and of itself says that it is an AI-generated video based upon the eyewitness accounts of others. Now, that's enough to disclaim the average viewer that it may not be technically accurate, but as long as it's substantially true and it isn't presented presented with malice, the journalists are free to report upon that newsworthy event with whatever tools they have on hand.
You think you'd be protected by Sullivan Against the Times by using an AI because there's no showing of malice, and you might even have done it in good faith? That I suppose that makes sense. What I'm wondering about is though whether, apart from the legal restraint you might feel with Sullivan, whether there's some kind of other ethical restraint by putting something out there that's untested and visually seems more efficient to the reader, to the viewers. They look at it, it makes far more of an impression than a witness. We all appreciate the public's right to know. So that's not going to get you anywhere. We all appreciate and we want the public to know. The question is the manner of presentation and the severity and possibility of distortion.
You might
I-
see.
Go ahead. I'm sorry.
Go ahead. Yes, please. Feel free.
I think that's absolutely a valid concern in the age that we're living in today. We should all be mindful of misinformation and disinformation. However, if the editor believes that it is aligned with their standards at an established newspaper, it's the lawyer's job to trust the editor, and it's our right to defend what they put out. And I think the ethics of certain practices are better left to journalists on the field. And I can have my personal thoughts, but I think my professional thoughts on defending our journalists would be very different. And I would stand behind their practices because you must.
Get up from here.
Yeah, well, so you're basically giving a green light to your editor to make this decision, but the consequence may fall to the defense lawyer for the senator here, especially because this clip is now being shared widely, notwithstanding the disclaimer that Editor Smith here put on very wisely, saying this is a reenactment. It's being widely shared without that disclaimer, leading many viewers to conclude that they were seeing the real assault. Does this concern you, Counselor?
Oh, yes.
I think my perspective on it as a private citizen would be different from my perspective on it as I assume I'm still playing the role of the newspaper's lawyer. It is not our duty to ensure that all we need to do, and it's not a duty regardless, that's just to limit our liability, right? Putting that disclaimer by the video. And we've done our part. And what happens beyond that is not something that we can control. In fact, almost anything is ripe for disinformation in the world. Anything can be taken out of context in the world. We are looking at that fake endorsement that President Trump posted, where he used that AI-generated image of Taylor Swift endorsing him. Just someone's existence in the world can be deformed to do something. This is a reenactment. And then that specific defamation claim would come down to the first individual user who removed the disclaimer and then reposted the video without the disclaimer. So I think that is within someone else's purview and within the social media user's purview and not within the journalist's purview.
So let me ask the defense lawyer here. Basically, the defense from the part of the media is, it's not my job. So what's your response to this?
I actually agree with that. The media can do what they're comfortable with. It's not under the purview of a criminal lawyer to enter into that. What is in the purview is, okay, if jurors or potential jurors view that, there doesn't seem to be much argument that AI recreation of the event would be inadmissible for probably a dozen reasons, one of which Judge Rosenblatt mentioned, that AI can produce gibberish. We don't know whether that visual depiction is accurate or how it reflects the witness statements. I mean, one of the interesting things is the difference between visual information and verbal information. I mean, the press can run those depositions and say, this is what the witness said, and that conveys a certain, that's a fact. But to show visually something that has so much more effect, and people, assume it's true, regardless of disclaimers. I think on the internet, there's one of those things, one of the catchphrases, someone says something and our response is, show me the pics. It's like, until you show the tickets, it doesn't exist. So once it does exist as an image, it's extremely prejudicial.
Well, hold that thought just a second. Professor Clark, does the law recognize a difference between visual evidence and textual?
Similar to that, which is.
You want to be on the microphone, make sure it's green. Yeah.
Oh, there we go. I was going to make a point similar to that. I feel like to some extent we're treating this as special and different because of the AI, and I'm not sure that's what we should be thinking about. I was thinking about the newspaper making the decision. How would this be different from having an illustrator do art that depicted the punch? That's going to require some interpretation, taking the evidence and coming up with a visual depiction like that, or even one of the news magazines on TV staging a recreation of it and covering this. The digital engineer is doing things to make the image come out, right? So it's as though that's the paintbrush or the pencil or the director chair. I think we have this tendency to, and I understand why, to think of the AI as a person and ask what its motives are, but it's really just a tool. And once you understand how it works, you can then assess these questions better. But by focusing on the people who are actually getting the AI to generate the material.
So if in a lawsuit, this is it extends the hypothetical a bit, but let's suppose there's a lawsuit in which either in a criminal case or in a civil assault trial, there was a fight and the jury has to figure out what's going on, who threw the first punch, who's to blame, self-defense and so forth. And one of the lawyers says, Your Honor, now I'm going to ask Judge Garry to put on your trial judge hat or your reversal hat. I guess I'm signaling. I guess that's how I think about this. Anyway, he said, Judge, we've heard 4 witnesses And they all gave versions of it, and that's for the jury, a jury question, and you'll instruct the jury accordingly. But I think, Judge, we'd like to put this in AI. We'd like to really show the jury what this looked like. So we're going to now show this fight with AI, and the trial judge says yes. And now it comes to the appellate division. Is there a big, like, reversed, or are you okay with that?
You know, I think for the reasons stated by Mr. Easton, I think there's going to be a real reluctance to allow this depiction. And I just jotted down, AI is just a tool, but the power of visual evidence is tremendous. And it's a recreation. It's not the thing, the foundation, the evidentiary foundation is really slim. The testimony is what the testimony is. We know eyewitness testimony has been subjected to some real scrutiny for its own, the issues that have come up around the unreliability of potential eyewitness testimony. But it's well honored in the law. This creation of a new, we're going to put this all together, it's too powerful. And yeah, I think, hypothetically speaking, I see reverse all over that. Yeah.
Yeah, I guess that we could, Judge Reed is smiling, also ready to reverse, I think. Judge Stein's ready to reverse. But is there, what about if it was on consent? If both sides wanted it, judges will rarely override when both sides want something. But there are occasions when the judge may say, I'm sorry, both sides want it, but I don't want it. I don't want this going to a jury. What would you think about that?
The key issue in evidentiary rulings is reliability. And it's going to be hard, I think, to convince a judge that this is a reliable form of evidence. A video of a scene, we see those all the time, and they're compelling. One of the things that's been transformative in a lot of trials is that everybody's got the phones, and the phones are, somebody is there, they say, I took this is the depiction, this is the film that I took. That's in a whole different universe than a film that was created based on some evidence that is real evidence. That's the distinction here. We see video all the time, and it matters.
But judges don't make rulings on the reliability of eyewitnesses. That's left to the trial process, right?
True
So-
that, but we make rulings on the reliability of evidence in the context of should this be admissible all the time, and that's where I'm questioning this, Mr. Smith.
For example, when we speak about police artists, that's a first cousin to this. So let's say there's a victim of a mugging and trying to describe it to the police, and the police artists makes a sketch of the person who did the mugging, of the robber. That's very useful for the police to catch the guy, but I don't know that many trial judges would allow that sketch into evidence of saying that picture, that's the guy what done it. I think a lot of trial judges would say, well, that's a police thing inside the police department. They could do whatever they want, and then it'll be up to the jury if they have the right guy. But admitting that into evidence as the offender, that's a whole nother thing, wouldn't you say?
I think that's unsurprisingly, Judge Rosenblatt, a brilliant analogy. I think you hit it right on the head with that.
Rehearsed all this before. You think this is unrehearsed? It was actually thank you.
But as AI grows more reliable, won't police departments be making use of that rather than artist sketches? And won't we I believe we will come to find pretty shortly, if we haven't already reached this point, that those can be practically, can be quite dependable, those sketches, for example. So it just seems to me that we might be at the point where this kind of evidence won't be as easily excluded as you might make it at this point. Maybe. No?
I think it's the difference between, as Judge Garry would say, the difference between an investigative tool on the one hand inside the police precinct versus getting in front of the jury saying, that's the guy what done it.
Yeah, that's cool.
To use English,
Interesting.
British phraseology.
Well, let's just figure out where we're going from here, because we were with Mr. Easton here trying to deal with the proliferation of this video that I guess your concern is going to be prejudicing jury pool against your client, right? That's going to be your argument for a cease and desist, demanding that the TAVL take down the video and release a statement, right?
No, I think that that's the newspaper's decision. What I would focus in on is jurors that see that and come to sit as jurors, they are, for lack of a better word, contaminated.
Yeah.
They've seen something that, as Judge Rosenblatt said, is unlikely to be admitted into evidence, and you can't unburn that visual image from the juror. And then the difficulty becomes, well, what do you do? And if there's 3 or 4 jurors that have seen it, first of all, how do you identify them? You got to talk to them on what they've seen. You have to do that one-on-one, because if you do it in front of a panel, you're going to contaminate the rest of the panel. So you gotta deal with that. And then it's like, you deal with it and exclude anyone that knows it, but it's got, I don't think that's a perfect means to do it.
So we're departing from the hypothetical. So you're saying you're just going to do that in voir dire, and you're not worried about it at this stage yet. You're not in the hypothetical. We have cease and desist, and you're going to try to demand that the TAVL take down the video. In real life, you're not going to actually do that.
No, I think what it would be is a preliminary motion to change venue, that you don't have to wait until there's a questioning of the juror, whether you can get a fair jury. You can't. And the court should take steps right now to remove it from the venue. And I think the venue is something that, in this particular hypothetical, crime is a local story. And a crime in Rochester versus a crime in Buffalo, Rochester media will be all over it, but not really care about the Buffalo crime. And same for Buffalo and Rochester. Now, this is like an Albany crime. Get it way as far away from Albany as you can. And I think maybe a more productive way of addressing this.
Well, let's just see what the DA thinks about that. If he has an early motion to change venue, are you going to oppose this and to take the case away from you?
Absolutely.
And how would you counter the argument that it's prejudicial already?
Every form of publicity would tend to be prejudicial to a defendant. Every form of publicity would tend to disperse to the whole community so everybody can read it or see it. But the system of voir dire during a jury selection takes care of that. Judges have the power to exclude potential jurors who may have been tainted to the degree that they cannot be fair in a jury trial. And you can remove jurors for good cause without losing a peremptory challenge. And judges also tend to give more leeway to exclude jurors who may have been too exposed but are not fully disclosing that exposure. Additionally, trial judges give instructions to jurors, and by and large, jurors follow those instructions, limiting instructions as to what they can do with, in fact, that they cannot rely on any information that they obtain from anywhere outside of the trial. And jurors give that guarantee to judges during jury selection before a jury is sworn. And during the trial, at various stages in the trial, the court will continue to admonish jurors about publicity, about information that they got from somewhere else. One of the reasons I actually truly I'm against any restriction of public information about criminal conduct. The community needs to know. It's part of the community's way of being assured and reassured that the system is working to protect them and to be aware about what's going on in society.
Well, that sounds good, but what if the publicity is generated by someone whom you know as DA to be a liar, and they're putting it out there in the news media day after day, information that you as the prosecutor know to be false? Can you ever imagine a situation in which there should be a change of venue, or is your position never, ever, ever? Because if I were an appeals judge on a case, I would say, well, all right, counsel, in this case, I can understand what you're saying, but then can you hypothesize for us a case in which in which a court should change the venue?
There are cases in which a venue change would be necessary. For example, when you have a child murder case after a child is molested and murdered by the individual, and that's in a small community, it's very hard to get. It would be very hard, in my view, to get a jury that can be fair in that instance. Yes, there are instances where a change of venue would be appropriate.
Well,
But
thanks for your answer. I think if you said never, you'd be straining some credibility in the eyes of the judges. Very good.
Well, thank you, Judge.
Garry.
Yeah, we're talking about voir dire and jurors with obviously high profile cases and issues of change of venue. I can tell you as somebody, and maybe this is sadly a reflection on my work, who has covered high profile crimes and written dozens of stories and gone to voir dire and sat there, and 3/4 of the people have no recollection or knowledge of the story whatsoever. And it's kind of painful to sit through, I admit, but it happens all the time. Maybe if I had an AI generated video with it, that would have changed it. But I think more often than not, the belief that we're poisoning the jury pool just really, it's a rare incident when that happens.
There's plenty of opportunity for pain here when Judge Garry was explaining how much more powerful visual is than words. This old wordsmith was feeling pretty impotent here. Yeah.
But if I could just chime in, I agree. I think for the most part, a change of venue is it's a hard showing to make. They are not often granted. And it takes that. In my time, I've seen some. We had some notorious murder trials that have been moved from one county to another. That happens. And especially if it's in a different media district. What's interesting is, with the proliferation of all the social media, I wonder if crime is still as locally interested. One of my fellow panelists said, "Oh, it's only of local interest," and I wonder how true that will be in the years ahead. But so far, we've been able to do that, but it happens rarely, but for the reason that Garry just shared.
Well, to your point.
If I could just add one little point, Rex added a fact to our fact pattern, which is this guy's running for governor. So I'm not sure the change of venue is gonna really help with that, right?
Yeah, actually, that's interesting. And to the hypothetical here, the Tattle has reposted the video with a disclaimer on the screen. The notion of this helping to perhaps mitigate the impact, but counsel for Senator Lennox is saying, nope, we are going to close the suppression hearing so that the press and the public don't hear anything about the inculpatory statements allegedly made that might be damaging to your client. And also, well, let's start with that before we get on to the other things. So if there's a motion to close the suppression hearing, counsel for media, Ojasvinee, are you going to oppose this on behalf of Tattle?
Yes, I mean, the Supreme Court has recognized that, the public must have access or has the right to access parts of court cases that have been historically public. And I think we will make that motion to oppose, counsel's motion to, keep the suppressing hearings behind closed doors. The public has the right to know. They have the right to know what the senator volunteered on his own. He was not coerced. He knew those who arrested him before, and while the dilemma about his Mirandizing, it's up to others who specialize in criminal law and arguing on behalf of him. I think the press has the right to know, the public has the right to be there, and we will definitely oppose that motion to keep the suppression hearing behind closed doors.
And Mr. Easton, how would you argue your motion to close?
Basically, it's prophylactic, is if you don't close this hearing, it will be publicized, and that confession or its admissibility is in play. And if it's suppressed or limited, jurors are going to be exposed to it. We're going to add to another level of prejudice. That's the Supreme Court case. Estes, where he was a swindler extraordinaire in Texas, and a tremendous amount of publicity. And there was a hearing about a suppression issue in the publicity. They wanted to close that, the Estes lawyer, and it wasn't. In the Supreme Court, United States Supreme Court, surprisingly said it should have been closed, and new trial, and reversed on that basis. I mean, one of the things too is it's the reenactment too of this that's particularly pernicious. And again, the United States Supreme Court has always been critical of reenactments. I mean, there's been cases where they reenact the crime, a kidnapping, and basically the United States Supreme Court says that is very dangerous and it's certainly inadmissible, but someone's exposure to it is so bad you can't have that extra sit.
I'm a little bit confused. You're talking about closing the hearing.
Yes.
I thought that was dealing with the admissibility of the statement in which he said he's been waiting for a long time to clock him on. Is that, or am I confusing two things?
Yeah, hearing on it would be basically
Of his statement.
of the statement. Yeah, admissibility
Pure
statement.
Huntley statement.
Yeah,
Yeah.
pure Huntley statement. So yeah, the standard thing for years and years has been where the judge would be inclined to think, well, let's not contaminate the jury and have the jury learn that he made this statement, because we have to weigh its voluntariness. We have to see if it's volunteered, voluntary, Huntley, Mirandized, not necessary to have Miranda, and so forth. So let's not air all that. The judges feel comfortable doing that. And the media says, well, no, we want all this out there. So
Yeah, and I think it's a competing interest. Is the media may want it out there, but that's their desires. But if it gets out there and the judge does rule that either all of the statements suppressed or portions of it, then the judges basically the case is veered into trouble. How are you going to pick a jury that's been exposed to something that's suppressed?
problem there is, the voir dire can get you a long way, and the judge can filter out all the people that have read it and so forth. But do you wind up, is there a danger? Is there anything wrong with having a jury that's living in a tree and doesn't read newspapers and is completely divorced from what's going on out there? Is that a healthy situation?
I don't think so, but I also think social media is really something that's taken off. And I think that I tried a case in Rochester. There was a salacious allegations, and it didn't get as much media, like print media attention that I thought. But the jurors many of them were immersed in details of it from social media. And then it becomes, okay, you have to quiz each one of them as how do they get their news? I mean, if they live in a tree and it's completely hermetically sealed, that's one thing, but usually there's something. And it's, picking it up from social media is the worst, because, the conventional media, at least there's an order to the process. You got the paper, you got the articles, you got the standards, but social media is just just out there with no standards.
I think, sorry.
Can you get can you argue to close a Huntley hearing even if the material is already widely accessible in the community? If this has already been reported by the tattle that he said this, isn't a judge going to say, yeah, too late, that horse has left the barn?
I think that's part of it, but also you have two competing interests here. The right of the accused to be judged by a jury that's not tainted by outside information against the right of the public to know. The openness of the courtroom is such that it requires a high standard of proof in order to cause a closure of the courtroom. And that's the right of the public to know, meaning the reporters being there and reporting, the public being able to walk into that courtroom, sit down and listen. And it's difficult for judges, and I think rightly so, to close the courtroom simply because the information that may be coming into the evidence at trial may be prejudicial. The prejudice that's of most important concern is what happens in the courtroom during the trial, as opposed to the publicity of the information. And when these horrendous crimes happen, there is excessive publicity. But prosecutors and defense attorneys and courts generally are able to keep the trial or the evidence within the confines of what the law allows. Some of the evidence that the public hears will never make it into the courtroom. For example, we're talking about AI in this instance. This AI thing is never going to be admissible in any courtroom, just like polygraph examinations. Police use that as an investigative tool. They can use it to build up reasonable cause to believe that a crime has been committed and that this individual committed the crime. But it never gets introduced into a trial. So also, AI is a novel scientific system. In order for it to be introduced in any courtroom in this state, I believe it needs to go through what's called a Fry test. And if it hasn't been fried, it's never going to go through. One of the things I worry about as far as AI is concerned is where AI is implicated in a system that's already been fried and accepted, found to be reliable and accepted within the scientific community in which it's developed. So, for example, DNA has been widely accepted and is used, and probably the most reliable identification system that we have in criminal cases. But when you have a mixture of DNA, suggesting multiple people, two or more individuals, the system requires a deeper examination to parse those separate individuals. And now they have developed something called a software called TrueAllele. TrueAllele can look deep into the results, into the data to separate and identify individuals better than your standard STR DNA can do. When in doing this new analysis by TrueAllele, it relies on AI. It uses AI information to do it, but AI has not been fried and accepted. So I think that's going to cause a complication in the legal, in the criminal justice system.
Fry, by the way, Fry is the case that creates a standard. It's called a Fry hearing. And before any scientific evidence comes in that's being challenged, the judge holds a hearing in keeping with the Fry doctrine, and the judge would determine whether it meets certain basic threshold points of reliability. And then, of course, it's left to the jury. But as a foundation for even for for admissibility, it would go through a Fry hearing like we did, like Judge Reed and I were on the court. Judge Smith wrote a lengthy decision about DNA. So if I were a trial judge, I would say that it has not been fried. At this point, it is half baked.
We'll be here all week, folks. So let's say that to vindicate your client's reputation, Mr. Easton, this poor senator who's been perhaps maligned by the reenactment that has been posted by the irresponsible editors of the Tattle. I'm sorry, Erica, for
That's
pointing to you
opinion.
at this moment. It happens all the time, right? You're going to vindicate your client's reputation. You filed some defamation lawsuits against the Tattle because they are defaming your clients by creating a visual record of something that didn't actually happen. Your client's contention is that he merely shoved back when he was being assaulted by this other lawmaker. And so and this has now spread to social media, to influencers who are embarrassing your client and in fact probably causing the failure of his incipient campaign for governor, right? What's your argument there?
Well, disclaimer, I don't really know civil law that well at all, but in this case, the primary goal is, the guy, his name is
Senator Lennox.
Lennox is, he's on trial for a criminal case. I mean, he's looking at jail. And your primary focus is win the trial, keep him out of jail. And then the defamation, that's goes underneath, or is the priority is the crime first. The defamation is, the damages, whether it was recklessly put out there, when it could be false. When you have something like this, where you have like 4 witness accounts, I don't know how you're going to be able to generate a AI visual depiction without, making a judgment call as which of those 4 is more reliable than the other. So I think that, they're setting themselves up for you were reckless in putting this out. And the disclaimer itself, whether it's on the top of the photo or the depiction, or whether it's embedded in it, I think is a distinction without that much difference. No one reads them anyway.
Yeah.
Like those things on your prescription medication, or the things on TV, like, possible side effects, and all of a sudden there's like a screen of like a million things and a guy speeding up. No one's gonna read the disclaimer, and it's completely ineffectual.
That printout is a Hearst company, by the way. It's supporting Erica Smith over here. Counsel for media, OJ, are you going to contest? What do you say about this defamation lawsuit? This comes close to being a slap suit, doesn't it?
Yeah. For those in the audience who are not lawyers and are just here attending out of the goodness of their heart and interest in the media, a slap lawsuit is a strategic lawsuit against public participation. And New York's anti-slap lawsuit, which provides a way to quash that strategic lawsuit, covers cases involving any communication in a place open to the public or a public forum in connection with an issue of public interest, or any other lawful conduct in the furtherance, of our constitutional right to free speech. And I think while it fails to pass the muster for a viable defamation claim against a public figure due to not meeting the actual malice standard, it also fails to meet the anti-slap law's inbuilt actual malice standard, where, if in the event that we were sued, in the event that we received a letter from Senator Lennox and his lawyer saying that they will sue us if we don't take it down and if we don't publish a retraction, we would write back to them saying that we will initiate an anti-slap lawsuit, which would then result in us recovering attorney fees and the like. And we'd lay out that heightened standard that they'd have to plead because this news gathering and journalism is fundamentally an act of public petition and participation, and asking someone to not gather the news because it makes you look bad if one allegedly committed an action that would make them look bad is not really, well, hurt feelings don't mean defamation. So it ultimately comes down to that. And yes, we would be filing an anti-SLAPP motion to heighten that burden that the plaintiff would have to meet and try and recover attorney fees.
I'm sorry, what motion would you bring on?
An anti-SLAPP motion. So this would, in New York, it would come as kind of a special motion to dismiss, or as a special, depending on where we are in litigation. But at this point, if they filed a complaint, as a special motion to dismiss, yes.
What relief would you be seeking? I'm not sure I follow you're going to make a motion for, and what are you asking the court to do?
To dismiss the lawsuit with prejudice.
Dismiss.
And yes,
Okay.
to dismiss.
All
yes.
right.
Sorry.
So this is really fascinating business. The AI depiction does not go through a Fry hearing. That would only be if in a separate case, someone wants to show what a fight looks like, and the judge would say, no, before any AI comes in here, we're going to have to hold a hearing. Here, the AI would be admissible. It would be the very item that the plaintiff is claiming defamed him. So of course it has to be shown to the jury. It has to be shown to the judge and jury saying, here, look at this. I am being defamed. So it's admissible, of course. But the question then is whether there's going to be a verdict for one side or the other. This is really a fascinating trial. Wouldn't it involve, let's see, maybe they'll ask the lawyers here, or maybe Judge Garry, if think about it. But we don't want to have you commit yourself. We want to be very careful with sitting appellate division judges. So we respect that, Judge. Would there be experts called on both sides as to the reliability or the distortional capability of that AI? It's in evidence. It's going before the jury for sure, because it is the vehicle by which he's defamed. So it comes in naturally. Question then is this going to be a battle of experts about how good or bad AI is? What kind of trial can we expect here? Anybody? Any thoughts? There's never been such a trial, as far as I know. Fascinating to think about it. Anybody have what kind of a trial are we going to have?
Wouldn't there be in the first instance an effort to get the testimony of the humans who enabled the artificial intelligence?
Yeah.
I don't know, what do you have to feed into it? Who creates this who creates this video that is generated by AI? What's the data that goes in?
This is almost like, what was it? The Wizard of Oz, where they pulled the curtain behind and there's Frank Morgan. Like, who's behind this? Can you cross-examine this non-existing entity? Who created the AI? Who's there that you can put on the stand and cross-examine that person as to its reliability? Anybody, any thoughts on that?
That the issue in a Fry hearing, wouldn't that be what the Fry hearing does? And traditionally,
Yeah.
that's you put in the scientists and the people who work on it to create whatever is requested of the AI system.
So you'd need experts. It would be AI experts.
Yes, and the computer scientists and all the people who generated the data that's put into the system to give you whatever result that it gives you. But one thing I am thinking about this issue that we have, the specific issue we have here, is that isn't truth a defense to defamation? The fact that the facts, as told by the eyewitnesses, say that, okay, this is true. And the AI generated image picture, and they say picture is is worth more than 1,000 words. But it basically puts into physical manifestation the words that people had used to describe what they saw. I don't think that, the case gets past this summer emotion for summary judgment.
Truth is a defense. It goes back to John Peter Zenger. It's a couple of centuries old, but the question is with AI, what is truth? I mean, can you ascribe truth to AI?
But in this instance, you have AI. If it's all you have, that would be one thing. But you have the words, the narrative told by individuals who confirm, therefore give you the reliability of what's created by AI. I think that's helpful in a civil context. And I've never practiced civil law, so I want to put that disclaimer there. But I would think in a civil context, it gives, because the standard of proof is lower, is different there. Preponderance of the evidence, I think, it gives you the existence of witnesses who have a narrative that's consistent and confirms what AI has done, saves my friend over here, from a lawsuit. But when you go into a criminal context, it's a different thing. It doesn't get beyond the investigative tool that it is for law enforcement to use.
How would you square that with one's experience with AI thus far, in which people put in facts that are incontestably true and valid and accurate and reliable, and you give it to AI and you ask for an answer and it comes out as utter gibberish? That's my experience. Maybe
Can
that's
I-
unique, but we gave really good facts.
Go ahead, sorry.
I'm going to quickly jump in with well, AI generally, and AI as it plays a role here. I don't think the tool is even the crux of the conversation. As we talked about earlier, it's just another tool that journalists can use. It's just another tool that society can use. And ultimately, it falls on the person, and assuming we're still talking about the defamation and not the admissibility of the video, it falls upon the plaintiff to prove that it was a false statement of fact that was published with fault, due to the fault of the tattler, and with actual malice. And as a video that, again, had that disclaimer that it was based upon the before eyewitness accounts that were also used by the police, by 4 people who were present at the scene, there's no way to prove whether it's true or false, because the video was generated based upon the assumption that those eyewitness accounts were accurate. And it says in that disclaimer that is that necessary generating input that was used, and that's what was relayed to the person who viewed the video in the first instance. So I don't think this is even about the AI. It's just about, again, whether we can even trust eyewitness accounts generally, as we have as a society for decades. That's been a part and parcel of news reporting for decades, for centuries even. And it's just another way of representing information. And you're right. Obviously, AI hallucinations are what they are, but I think the facts here say that it was realistic. So I don't think it was gibberish. That would be contradictory to what the alleged harm even is. And I think we would just be invalidating centuries of journalism if we were to invalidate just a technology that was used to portray representation of eyewitness accounts.
Well, with the eyewitnesses, we've been hearing from eyewitnesses describing fights for centuries. But these eyewitnesses have to go before a court, swear to the truth of it, and undergo cross-examination. How do you cross-examine an AI? You can even make a due process argument that a witness is a Sixth Amendment right of confrontation. How do you cross-examine? How do you deal with some entity that is accusing you of something that you have no way of confronting and no way of cross-examining because something went on in the innards of that AI process, whatever it is, and you can't ask the AI a question. How good is if it's a witness, what about your eyeglasses prescription? What about the distance? What about, a lot of other things that are standard cross-examination in eyewitness cases? How do you cross-examine an AI piece? If I were a lawyer, I would say, I'm being deprived of due process. I cannot examine this thing and it should be inadmissible. Of course, that's in a criminal case. Its utility as a vehicle for defamation, that opens up a whole nother question, of course.
Could I jump in? Whenever we start to focus on the AI, I think we should pause and refocus on the human beings who are using the tool. They will have written something into the input of the AI to get it to create the image. And it's got to be pretty detailed, and they're going to base it on what the witnesses said. You can cross-examine those people. What did you put into the AI tool as your input? Anybody who's tried to generate pictures, I played with this a while ago, asked to put a barge in the Erie Canal in the 1850s or something. The pictures that came back, my favorite, the horses pulling the barge were in the barge with the passengers. You have to be pretty detailed about what you want to depict. And so I think you cross-examine on what went in, you cross-examine on which AI model they chose, what the data was that model is drawing from, which you should know if you're using one of those models. And somebody will have looked at this after the AI produces it, and they will have approved it and gone ahead with it. And so, human beings are not removed from this process. There's cross-examination there. I guess the final point I would make is even with the eyewitnesses, those jurors are developing their own mental image, and those mental images are not going to be consistent with exactly what happened if there's not a visual representation of it. I'm going to hear the witness, how far away, this sort of thing, but I'm picturing something, and every other juror is picturing something, and they're not going to be the same. And so I think you're never going to create an exact duplicate of what happened, even with the witness testimony.
I don't know if it's a defense technique, but to throw stuff up on the wall and see what sticks. Wouldn't you try to file a defamation suit against the AI and claim that your client has been defamed by this technology, and therefore seek to have the court order its removal?
It seems to me the conventional mode would be go after the programmers. What was the AI doing if it's getting contradictory information from one witness or the next, or the same witness? What's the protocol? Who decided that? And that would be the conventional one, but my imagination was not, good enough to come up with sue the AI itself.
Well, as somebody in Georgia did, I'd just like to point out that Superior Court of Gwinnett County, state of Georgia, last week said that the defamation suit against ChatGPT software fails because of the inability to prove actual malice. So software can't have actual malice, I guess. I guess you're right. I guess that was just too far-fetched, but just so you know, some lawyer had the imagination to do it anyway.
The AI, it's like, I don't know why they can't come up with malice. It'd be the AI equivalent of malice. I think that seems to me a little bit of a dodge. I think in this whole defamation case is like, if on a practical basis, if I were a judge, I'd put it off until after the trial, because either he's going to be acquitted, which will put some juice into the lawsuit, or convicted, which will deflate the lawsuit.
Right. So while we're talking about the trial, let's move into the trial phase here and say, Senator Lennox is now getting into a social media war with his alleged victim, as well as the witnesses, the prosecuting attorney, and the judge, Judge Barbara August, who is hearing the case. He writes that members of the jury should be prepared to hear the case with objectivity, and comes to the obvious conclusion that I am being persecuted by my political opponents and a corrupt district attorney, and the public will surely be watching as well with fury. So by the way, as you're reporting this, so here you see these social media posts and you're the reporter covering this trial. Do you have any concern about reporting the allegation that the DA is corrupt? And whenever you report, and do you get the DA's response to the allegation of corruption?
Yeah, that's a good question. I tend to kind of let the social media live its own life. I worry that if we, and sometimes that life is good and sometimes it's a quagmire. And sometimes if we step into the quagmire, we're going to sink. But if the social media becomes so prevalent, sort of so much of a focus of the community talk, it's hard to step away from it and not report on it. So there's where that line is, it's hard to say, where it goes from, okay, I can close my eyes to this, to, okay, this has become the talk of the town and we have to talk about it, even as outrageous as it may be.
And you're okay with publishing this as well, editor? You're going to publish the nasty things said in social media by the senator about the DA and the judge?
I think he's right. It's that finding that threshold and what it is. If this is a politician who's talking to 5 people and nobody's responding, I'm not going to pay attention to it either. If he's talking to 5 people, but 500 people are responding, it's a very different measure. And then I think, yeah, we do take a measured response. We're reporting this all throughout. You guys realize that, right? It's not like it was stopped at the AI video. We're still reporting.
Right, because he's still running for governor, presumably.
Yeah.
Yeah.
And to be clear, it doesn't mean we're going to report the most outrageous things on social media. We may find a way to sort of tiptoe around them and talk about the community conversation around it without getting to the stuff that just seems so far afield.
Well, you're going to, but there are social media platforms that will report about everything that's out there, right? There's the statewide equivalent of Steve Bannon, who's just going to be fairly wild out there. And that raises an interesting question about defamation. Well, we'll get into that later. Because the instance of the hypothetical has the DA actually asking for a gag order, a rather sweeping gag order that would stop the parties in this case, attorneys and agents, from disseminating publicly or discussing with any print communications medium anything about the case which could interfere with the fair trial, including statements about court personnel and so on. Have you ever contemplated such a thing? Do you think that's a good idea?
Definitely not, because you give oxygen to the whole idea of what he is claiming. I think it's political nonsense, and I wouldn't give a moment of thought to it. I wouldn't waste the court's time asking for any sort of protective order. As far as what he is saying or doing about the DA is concerned. But in terms of what he is saying or doing about court staff, even the judge, I would have a concern about that, because it's something that threatens the integrity of the of the case in the judicial system. It's something that could chill the participation of jurors in the case. And I would encourage some limiting, protective order against him in that regard. But as far as the DA is concerned, that's,
Yeah, I've been struggling also with the extent and scope of a protective order or some kind of gag order. If a defendant, after the trial starts, goes out and says, the judge and the DA are corrupt. And now I haven't experienced this. I haven't encountered it. This is all new. This has happened in the last, few months and years. We haven't experienced, I went through years and years on the bench and that never happened. So I suppose if it happened, I'd say, wow, I guess the First Amendment, he's allowed to say that as far as corruption of the judge and the DA, but I would say, if you mention anything about witnesses, you're now in contempt. If you start intimidating witnesses, you're going to go to jail. I could say, would feel reasonably comfortable saying that. But you say the same, you would say lay off of the judge to this defendant. You would ask a court for a gag order that he should not accuse the judge of bias.
Absolutely, unless he has evidence that the judge is in fact biased. Because that type of accusation, it does take away from the need to see the court, as part of our system, as a reliable system of justice to, decide cases impartially, especially where you have a jury trial.
Interesting.
If he is so upset with the judge, he can ask for a jury trial. He doesn't, and he is a public official and possibly a lawyer bound by ethical restrictions about what he can say about others.
But let's suppose that this Lennox fellow is not a lawyer and that he has a jury. And he says, I don't know about the jury, but the judge is corrupt. I wouldn't trust him the way he instructs the jury.
Well, it's still, I would still ask that he be controlled.
That's interesting because if Lennox stood up in the middle of the courtroom and said, Judge, I'm sick and tired of listening to your stuff. You are corrupt. That could constitute a contempt on the judiciary law, could it not? I mean, I'm not expert in this because it's so unusual, but I should think that at least arguably it might be a contempt under the judiciary law. So it would be bad right in the courtroom to the judge's face, but going outside with a microphone and speaking to the world, saying the same thing is maybe more protected under the First Amendment. What do you think about that? I don't know the answer, by the way. I'm just airing this.
Well, I think, there is a First Amendment right to criticize the process, but there's ways to criticize it.
Right.
Here, it's, by political opponents, the corrupt DA, the public will surely be watching this with fury. That is something that goes well beyond the plaintiff or the defendant here just saying, well, I got some problems with the rulings. He was wrong on this, wrong on that. A critique that's based in reason, and that's fine. But to say he's corrupt, he's ruling wrong, and the public is going to react with fury is intimidating to the judge, corrupting to the process, and jurors who get wind of it secondhand. It's very pernicious to them.
Do you think it could be, it could result in a legitimate gag order that would withstand the First Amendment challenge?
Oh, I think so.
You think so?
And Judge Garry, could you impose such a gag order absent a motion from counsel?
I'm not sure, but I think that, but expressing this in a more roundabout way, Mr. Smith, the issue at stake is we do have a First Amendment right to express opinions, and it's a strong right. And where it crosses the line is where it becomes a threat, and where it becomes a real danger. And in my view, this, saying the public will react with fury, it's close, it's almost, but is it crossing that line? It's a pretty well-written statement in this, in right, it's almost a threat, but it's not a clear threat, and that's what's written into our scenario here. We have all, when I read this at first, I thought how interesting to have a problem that's more ripped from the headlines than probably in a lot of years, because we have all just seen where gag orders were deemed necessary and upheld, at least at this point in in the federal courts.
Can I ask a question of the judges and lawyers? Because you hit on something I'm curious about. Where does the line become then between that point where, oh, the public may revolt and, respond to basically saying respond? Where's the line? Or is that the line that you basically have to say, public, go out and do something?
That
Can you
makes-
Elaborate, I'm not sure I get,
Well, where is the line that we're drawing here? We're basically questioning whether the language here could incite the public. And seem to become an conclusion that maybe not. So where does that line become? And I swear I'm arguing the other side here. Where does that line become? Is there somewhere short of basically telling the public, go out and do your thing and respond and take care of the judge or something horrific like that? Is there a lesser threshold that becomes problematic?
I can try to address that. I think we shouldn't necessarily slip into thinking that this speech is protected unless it crosses the line into incitement. That would be one way it would lose protection of the First Amendment. And this seems to me falling short of that. I agree with Judge Garry on that, given the incitement standard. Or it could lose protection of the First Amendment because it's a true threat. I think this falls short of that as well, where you put somebody reasonably in fear of bodily harm. But what would more likely, I think, and correct me, anybody who's more versed in this than I am, what I think the issue here is it loses protection of the First Amendment if it's so extreme that it interferes with the administration of justice. And that's a different basis than incitement or true threat. And to me, it seems like that may have a lower threshold, and this conceivably could reach that.
yeah, hard to draw the line, but here, I think we can give a couple of illustrations of what is on one side of the line or the other without necessarily drawing it. If this rambunctious defendant holds a press conference that says the judge is corrupt, I think most judges would just let it slide. If the defendant said in the courtroom, you're corrupt, now we're playing with something close to criminal contempt in the presence of the court. So I would draw a distinction between if the defendant or if this Lennox character said it to the judge in chambers without the jury being there, maybe that might be not punishable as a contempt in the presence of the court. But if as the jury's sitting there and he says, you're corrupt, at that point, to me, that would be a contempt because he's undermining the integrity of the court. He's now saying something that's going to be, that the jury is listening to. The judge is being accused, the very person who's going to give them the law is being accused of being corrupt. That's going to undermine too much. That would be a contempt. I'm just saying my instinct tells me that would be a contempt in the presence of the court. Said outside the presence of the jury, less so, but I don't know. I don't know the answer to that.
If I could add a little bit, when you focus on the actual gag order issued here, some of this is unconstitutional. Some of it's just way too broad. It's going to have to be focused on pretty closely on what the person has said. You can't say anything about the case. That's way too broad because these are prior restraints. And the very bedrock principle is this comes to the court with a heavy presumption of unconstitutionality. The burden is heavy on the person to justify this. And things like statements intended to influence public opinion, that's just way too broad. Some of the other things are more specific. And if you ground those back in interfering with the administration of justice, then you have a better chance with those narrower pieces of it.
Sure, and another one again in the line drawing, this system is corrupt, the judge is corrupt, says that in a press conference outside. And let's go down to the courthouse and let's show them. Now we're talking about, was it Blockbuster, Chaplinsky against New Hampshire, the fighting words cases,
yeah.
which, as you so well point out, are not worthy of protection.
So short of a finding, we're short of that standard, but in this scenario, we have a gag order imposed that restricts, say, an op-ed from, on the point, on the part of the defendant. Does that cross the line? Is that an unconstitutional prior restraint? Probably so.
I think our professor friend expressed the law on prior restraint very well. That heavy presumption and our freedom to express is sacrosanct.
Sacrosanct. There we go.
Sacrosanct, thank you. So I think that's going to be governing in that respect. I do, as far as Judge Rosenblatt's, I've got a quote from a case here that a court cannot sit back and wait for a carnival atmosphere to descend before acting. And, that's, so the court is in a tricky spot. We can't go too far with limiting speech. Certainly the prior restraint is significantly curtailed by our law. And yet in the courtroom, we cannot allow the administration of justice to be altered by expressions, and certainly not direct threats. Direct threats to judges may be more tolerable than threats to witnesses and other participants.
So the carnival atmosphere might proceed outside the courtroom here, say, and there may be great speeches by the senator and his supporters saying that the allegations against him are partisan, the eyewitnesses are all, we need to check to see if they were paid by this unnamed other senator who assaulted Senator Lennox in his telling. The judge is corrupt, the system is out to get me. How far do you allow that to go then before some sort of a motion from defense or action by the judge is tolerated? What amount of carnival is constitutional?
I mean, I think it depends on the facts. Does it cross the line so that what the senator is saying is likely eminently to cause that crowd to mob the court and break through the doors, as happened in January in 2001, 2021, perhaps. Or does it cross into a true threat? A little harder for me is where the line is between permissible and what's going to so undermine the administration of justice that the court should intervene. And the judges probably have more experience to speak to that. But I will say, I think the best guidance we have from the US Supreme Court with this heavy burden of proof is the court is going to have to think about how effective this order is going to be. They're going to have to think about alternatives short of that, change of venue, voir dire, jury instructions, and will those cure the problem before intervening? And part of that assessment is the realistic. How realistic is it that the problem is going to erupt?
So drawing near to the conclusion of this hypothetical, we have the trial date nearing and the judge determining that the courtroom will be closed for voir dire. Jurors will be allowed to remain anonymous for a period of 5 years after the trial. Media, I presume, might oppose this. Is that right, OJ? Would you oppose closed voir dire and anonymous jury?
Yes, we would oppose both. As other panelists have mentioned earlier, again, there's a strong right for the public and the press. It's the press's duty, almost a democracy, to report upon what's going on behind closed doors. The press's role here ensures that proceedings are conducted fairly. It discourages misconduct. It provides a controlled outlet for the community to opine in, and it kind of secures public confidence in the jury selection, and consequently the consequences and the disposition of the trial. And yes, so for those reasons and for the First Amendment, we would oppose both.
Well, we have increasingly seen instances of anonymous juries lately.
Yeah, I've mellowed on this position. When the defense bar originally, our position was anonymous jurors, the jury it creates an atmosphere of danger, intimidation that wouldn't be there if it proceeded regularly and they had their names. So we used to fight that all the time. But as I see what's going on in some of these cases where jurors they do feel this exposure that social media and the paparazzi will come in and disrupt their lives, and with good reason. I've turned the corner. It's like I do think it, even though it presents problems, it's really it's a rear guard action to protect it. But I think it's better than not have it.
And is that a prosecution viewpoint also these days evolving?
Well, I think closing the courtroom should be in exceptional circumstances. I don't think it's something that any judge takes or would take lightly. You have those scenarios where, I mean, the judge has to make a specific finding to entertain closing the courtroom. But also, if you close the courtroom and exclude family members of the defendant, friends and family who are there for his emotional support at this critical time in his life, it's likely to result in a reversal of any conviction. So those are factors that I would consider seriously before asking the court to close the courtroom. I have had occasions, I've tried 4 murder cases this year. In each and every one of them, they had serious, public interest reporting them. And in some instances, it seemed necessary to ask for limited access to the press because some of the reporting was adversely affecting victims and their families. And I was getting this complaint constantly. And I was tempted, but I never went there because you basically open a can of worms that might undermine you if you were to achieve a conviction down the line. So I don't think any prosecutor would, somehow just willy-nilly ask for the courtroom to be closed.
Well, can we agree that an anonymous jury is nothing the defense ever wants? It just creates an aura, unspoken. This guy must be a very bad guy indeed, because we're not even allowed to, we don't want anybody to learn anything about us. So it's adverse to the defense, adverse to the press as well, because it's harder to find people and talk to them and interview them. So, and the DA is more or less indifferent.
To the anonymous jury. Yeah.
Well, I mean, is the jury really anonymous? They have been summoned to come into court, so their information is known. The question is whether their names and personal information are known to the defendant, the accused, and his or her lawyer. And the person is getting a trial in open court. The person is facing the witnesses in open court. What's the need for the accused to know the names of those individuals beyond the scope of voir dire to determine if these individuals are known to witnesses, if these individuals are known to the prosecution, or may have some type of influence in the case beyond the information they disclose in the jury selection. So I think in the voir dire, that would normally take care of it. I think it's important, whether it's for a trial for a larceny, where the person steals a pack of tobacco, or for a murder case, that all victims and witnesses and jurors deserve some element of protection within the judicial system.
Yeah, Judge Garry, I think wants to say something.
Yeah, in fact, we are seeing a greater tendency, a movement, if you will, toward more use of anonymous jurors. But I think it really needs to be said that at present, there is the statutes do not allow at least the names must be provided. So that's in the criminal procedure law, the statutes that govern this say that the court shall direct that the names of not less than 12 members of the panel be drawn and called as prescribed. And there is a companion statute in that area that allows the limiting the disclosure of juror information regarding their business or residential address of any prospective or sworn juror. But even that is upon a showing of good cause, such as a likelihood of bribery, jury tampering or physical injury or harassment of the juror. So as recently as 2018, the Court of Appeals said it held that it was error to anonymize jurors without, here's the quote, a factual predicate for the extraordinary procedure. So it's still at this time really an outlier. And in 2024, I don't know that there's any potential appeal. I don't know what the potential for that would be. I don't think that they would be, but we have issued, the third department, my court issued 2 separate decisions, both where the issue was preserved by objection and where it was unpreserved, saying, based on those statutes that anonymous juries would not be allowed. So there's some real limitation on it. And Mr. Smith, I think you said it may be changing, and maybe it is, but the state of the law at this time it's an extraordinary procedure, and you would have to show what the danger is in a fairly particular way, because you would be called upon as a trial judge to make other, limitations that would meet that.
We all find this something to be very careful about and don't want to see it expanded and keep it in the rare case. Who's more harmed in this, do you think? The defense or the media, or does that matter?
I hadn't thought about that. I'm sorry. Maybe my friends to the left there have a thought.
Who's more harmed by an anonymous jury? The defense, the media?
I think it's the defense. The media, as Judge Garry has said, the names are available. There's no way that you're going to get, vaporize those names. And I don't think the jurors the issue is so much their fear of the defendant. I think it's the fear of people knocking on their door afterwards and asking them. And that's been my impression. We've always asked the judge for permission to talk to the jurors afterwards. Not in terms of, their verdict so much, but in terms of what we could do better, what worked, what didn't work. And generally that works. I mean, you're given, some jurors just don't want to do it, others do. But that's, I think, the concern is jurors don't want to be harassed or followed out of the courtroom, have some media member come to their place of business.
And what about the seemingly increasing incidence of judges instructing jurors, you should not talk to the media after this, because we have seen that happen.
Yeah, I've never seen it. I think that's very problematic. That juror, once that trial is over, that juror is a full citizen and has a full panoply of First Amendment rights. It is not under the subject of the judge, and I don't believe I think it's very problematic constitutionally.
There's no remedy. The judge does it. That's the end of that. a lot of judges might put it a little bit differently. They might say, oh, look, you know, you don't have to speak to the media if you don't want to. If you do, there's nothing I can do about it. I just think it's a bad idea. I think a lot of judges might feel comfortable with something like that, and they'd feel okay. Or they could be a little more neutral and say you can, or you don't have to. Bear in mind, you don't have to. Are you listening? You don't have to. That'd probably be okay.
Not going to stop Mr. Craig from knocking on their door the next day,
door.
you know?
Yeah, thank you. There actually is some benefit of the media talking to jury all the time. No, Bill Easton will probably disagree with me, given that I spoke to the jury in a very prominent case that you had. You know what I'm speaking of. But sometimes it actually, in some of the cases, they're difficult perhaps for the public who was watching spottily, et cetera, to figure out why a jury reached a verdict. It actually kind of serves a public service if you can get those jurors to really sort of take you into the deliberations and spell out why and what they did.
Sure.
And the other issues is if you got a bad jury, and you know the media may be able to get to that in the aftermath.
Defense lawyers would like to know it's interesting to take yourself into the jury room and find out what happened. We learn a lot. The last thing in the world the DA wants is people talking to jurors after the trial, because it's nothing but headaches. Because if the jurors say, oh, well, here's what happened in the jury room, next thing you know, motion for a mistrial because somebody said something that was improvident. So the DAs say, don't do this. It's just a bad idea. DAs have everything to lose with post-trial discussions.
Appellate issues, you know, being raised in that context.
Sure.
And well, the reason the jury convicted the individual is because the proof is there beyond a reasonable doubt, as they are instructed by the judge, as the law requires. The concerns that we are addressing in this context are the same concerns that have been recognized by the legislature, New York State Legislature. For example, in the new discovery laws under CPL 245, there is protective order for victims and witnesses of crime where there is a concern of intimidation, witness intimidation or interference. So if the law recognizes that danger or that concern for a witness or for a victim, how can we say it's not appropriate for jurors who are going to be the ultimate deciders, and then where a defendant or I mean, some defendants, we know the kind of, so there are defendants out there who would do something to believing that it's in their best interest to undermine a case and get, be acquitted or undo the trial. How can we not recognize that possibility to protect jurors? And I think the anonymous juror is a good way to go.
I don't know the answer to this. We have a statute in New York that Judge Garry read, Justice Garry read, in the federal, in which the names are given out, so they have names. In the federal system, do they conceal names as well? Does anybody in the room know? In the federal court, are even the names withheld from anyone's view? I don't know the answer.
Had a federal trial, 4-month trial involving a motorcycle gang.
Yeah.
And the names were out there. But there were efforts taken to not close the courtroom, but there's ways to close discussions between the judge and the juror, and the jurors imparting information. Juror approaches the bench, which is customary in voir dire, and airs out the personal things, and it's effectively closing the courtroom because that interchange is transcribed, but no one can hear it. And that's what went on in the case that I'm talking about. So I think in the federal system, the names are out there. And I think even more so than
You think they have a statute, or is it discretionary? Do we know?
I think there is a statute that you're entitled as a defense attorney to the whole roster.
Names.
Yeah, of the names.
Well, we have reached the end of our hypothetical. By the way, I didn't give credit at the top. The authors of the hypothetical, one is not here. Mike Greigel is with counsel, is counsel to some case in California. He had to fly out yesterday unexpectedly. Casey Seiler, the editor of the Times Union, co-author. Great work, guys, on this hypothetical. And that brings us actually to questions. Did you get any, whoops, there you are, Bill. Do you have anybody from the field?
I do not current. Can you hear me okay?
Yep. Nope. There you go.
I do not currently have questions online, but if you are joining us from Zoom, please feel free to type in your questions in the chat. I'm keeping an eye on those. Anybody in the
And
room?
out here, whoa.
I'll be right there.
Oh. Do the Phil Donahue thing.
Sure.
I'll make an observation and then then the question, just some of the issues, while social media is new and artificial intelligence is new, some of the issues you're discussing are not new at all. Like you mentioned, it goes back to John Peter Zenger back in 1735. What is truth? Well, actually, that was what Pontius Pilate said to Jesus at his trial, what is truth? So some of the issues are not new at all. And we were talking about pictures worth 1,000 words. And I remember in Boss Tweed, the famous Tammany Hall boss, saying, I don't care what the media says about me, just don't print cartoons showing me taking money from the purse. That's what I'm afraid of. I don't care what they say, just that. I did sort of have one question, though. A lot of this was focusing more from the DA perspective. So like, go back to the sketch artist there. We can't let the DA put a sketch artist in, but what if the person arrested doesn't look anything like the sketch artist and the defense wants to put that in? I had a case like that once many years ago. So similar to that, not exactly, but should
Is
that be
that-
allowed in? And I guess sort of the follow-up question I'll ask is, we're kind of treating the media as a monolith. And I'll maybe take the Trump case some of the Trump cases as an example. You turn on the 6 o'clock news, CNN, CNBC, ABC, CBS, they got one version. 7 o'clock, you turn on Fox News, they got a totally different version of what happened in the courtroom that day. So the media, media is not always monolithic. How do you handle that from the defense viewpoint?
Wow, what a great point. The use of a police sketch to cross-examine the victim. So the victim describes the robbery. Yeah, that's good. Do you see the defendant here in the court? The guy the robbery says, yes, that's him. And that guy is 5'3" with blonde hair. And defense says, well, we got a police sketch here where you got somebody 6'9" with black hair and can confront. I would say, yeah. Cross-examination. I would allow it as a trial judge. Prior inconsistent statement. Absolutely. What a nice point.
Yeah, I think there's not a symmetry between the prosecutor and the defense.
Right.
The defense has a right to confront witnesses. The prosecutor doesn't. The defense wants to put that in. I think the defense should be allowed to do it. Reliability or not.
I'm not so sure I agree. Prosecution doesn't have a right to confront witnesses. Yeah, any witness that's called by the defense, the prosecution has a right to confront that person. If it is a witness, put forward by the prosecution, of course, the defense has the right to cross-examine that witness. And I would imagine in this instance, the use of the sketch would be to challenge the credibility of the identification of that defendant at the time that the police, the information was given to the police to facilitate the investigation and ultimately leading to the arrest. But I cannot put that sketch in, especially if I know that this individual is in fact the one who committed the crime, but the sketch doesn't match up. If as a prosecutor, I have an obligation that if I see that this individual who is being prosecuted does not match the sketch, and there is a strong indication of misidentification, I have an obligation to look into that and possibly not prosecute the case unless there's other evidence that supports the individual's guilt. But I cannot put it in, even if it matches. I am not allowed to put it forward because the in-court identification is what's going to control.
Isn't it
Other
Brady material?
observations?
Aren't you
Oh,
obligated?
thank you. And that's exactly one of the reasons I wouldn't pursue the case if the identification does not, if the sketch identification does not reasonably match the individual, it might constitute what's called a Brady material, potentially exculpatory material for the individual. And as a prosecutor, I would have an obligation to disclose it to the defense attorney.
Button on the side there.
There we go. Now it is. A question for my colleague Erica and for Mr. Easton. In discussing the idea of a venue change, does digital journalism render the intent, the functionality of a venue change moot? Because now, of course, it used to be that media, or at least print media and even electronic media, meaning TV and radio, was so regionalized or localized that you could move a proceeding to a different part of the state and expect that the jury pool was going to be less aware of it. I just love your thoughts. You kind of touched upon it, but I'd love for you to unpack it a bit. Does the fact that the news is happening everywhere all the time now make a venue change less utilitarian?
Well, as I see that, and I'm not so sure that this is directed to me, but I have a thought on it because it's, I think it's the local interest where the crime happened or is being prosecuted is more heightened than anywhere else where they say, oh, look what happened over here, look what happened over here, as opposed to the local people who are saying, oh my God, this happened here, this is home, so being a bit removed from the scene makes it makes it less likely to be concerned. Being in the scene raises the concern that I would imagine my colleague here would, be concerned about. It still wouldn't make me go along with his motion. I'll still fight it.
I'll still make it. So, the venue change, I mean, it's all we got. It's like, it's the only remedy. I do think there's something to it, is removed from the location where the pressure is most intense. The United States Supreme Court, I think, has addressed venue in the last couple of years twice. It did it in the Enron case. And the defense wanted to move it out of Houston because so many people were employed by Enron and the community was outraged. And the Supreme Court wrote out it fairly extensively and said that's actually true, but there's nowhere you can move it. This is national publicity. Enron has been vilified and portrayed in such a way, it doesn't matter. So the venue change really wasn't an issue. Same thing with the Boston bomber case. Venue was denied at the trial level. First Circuit then says should have been granted. You can't try that case in Boston. And for a lot of reasons, but it goes even beyond publicity. But publicity was one of them. And then the Supreme Court then said, no, the judge, they didn't agree that it was a good place to try it necessarily, but that the court was in its discretion to do it. So the venue change is a very imperfect tool to do it, but I think it's better than nothing.
Isn't there a case? I suspect it may be pending appeal in this jurisdiction in the third department. So I don't want to. I'll just ask the question. Isn't there a case? I think the limo driver case that occurred with a lot of people killed wasn't there a motion made to change venue in that instance? And I believe that motion was denied. Yeah, and given the horrendous circumstances of that case, which most defense attorneys would be triggered to say, we want a different venue. You know, I'm not so sure that a change of venue in that type of case is going to achieve anything different for a defendant if the proof is there that he or she is guilty.
I'm not so optimistic there. I think it would happen in Schoharie County, which is a very small county. And then, you know, if you're trying it in that county, a lot of jurors are going to have incidental contact with not necessarily the victims or the mechanic or whatever it is. And I think there's a strong basis to change venue, given the small jury pool is one of the considerations.
Strong basis to make the motion.
Yes.
Any observations?
I think one of the interesting things about this case too is we're talking about state senators. So it may have happened in Albany.
Mhm.
It may be senators, people from Albany, but man, that story is going to be picked up across the state. So even if you try a change of venue, you're going to run into people who've heard of it. And the more we keep pouncing on it, the more the story is told, the more likely a story like this is going to become a punchline on some show somewhere that is much bigger than the state itself too. So being able to get this out of this area is going to be hard. Even if these lawmakers were from, let's say they're from Western New York, they just are here working, but they're actually from another part of the state. It's still going to affect the entire state. So I think, I mean, from media standpoint only, I'm playing a lawyer here. I feel like a change of venue would be really hard, right?
Well, it's always hard.
Well, yes, this type of situation where you're talking about something that crosses lines so much.
Yeah, it may
It's kind of the
depend.
opposite of
Yeah,
scary.
if the jurisdiction of the state senator Lennox was in Albany,
Yeah.
I think you have a much stronger argument. But if he's coming in from Buffalo, I don't know what you're going to get so much. I do think there's an Albany component to it, though. It happened in the state capitol, and it's still worth making the motion.
Yeah, the emotional connection to the case is maybe very strong, but when all is said and done, you still, you have to pick 12, maybe 12 jurors, maybe 2 to 4 alternates to participate in the case who commit to being fair, no matter where you go, whether it's in the jurisdiction of the crime or if it's removed to another place. So that is still a task that no matter where you go, you have to perform, and the court has to perform. And if you find jurors that are committed as are required, that's all you can ask for.
And with that, we're going to have to say it's 4 o'clock, which we promised would be the time that we get out of here. What a great panel this has been. Thank you. A reception, I believe, right?
Yes, everyone. Thank you all for joining us this afternoon. Those of you who are in person here looking for CLE credit, please stop by the CLE table on your way out. Make sure you give your forms to Lisa Rivett. If you don't, she will find you. For those of you who are here in person too, please join us on the first floor in the East Foyer for a reception. The elevator is working again. I apologize for those of you who had to take the stairs. For those of you who are online, thank you. Have a great night.